right, so I want to kind of move away from the documents themselves for the next several minutes and talk about the kinds of services that you might look for when you're having the documents prepared and beyond. Because sometimes the services that you get with the documents are as important to making your plan work when you need it to work as the documents themselves are. And I really break this into two categories. I like to talk about it in terms of a documents-only estate plan and a documents plus comprehensive services estate plan. And sometimes I call that a curated estate plan model. So really these are two different service models. You will see attorneys in this area and beyond, I think really come out more in the camp of documents only. It certainly has been the common practice throughout the United States to have more of a documents-only approach. And that's where you go in, you see the lawyer, they tell you what you need, they put it in place, you sign the documents, you walk out the door with a set of instructions on now how you make the documents work for you. You fund the trust or add your beneficiary designations without really a whole lot of input or support from the attorney or the attorney's office to making sure those things happen. And some people are very good at getting those things done, but most of us need a little bit of support as you go through that arduous process of getting all of your assets into the trust, for example. You just need some help making sure it happens, because if it doesn't happen, it's catastrophic failure at the end when it's too late to do anything about it. I want to kind of highlight that, that situation with a little story that happened to a friend of mine named Allie and her family that utilized the documents-only approach. And I don't think they knew that what was happening. And I think you could be in that same situation. I want you to be able to distinguish when you're talking to a lawyer about estate planning. Am I going to just get a set of legal documents, or am I going to get documents and support to make sure they're fully funded and I'm fully supported in getting through the entire process, and so that the estate works for me when I need it to. So my friend Allie, she's a lawyer about my age, and when she was in law school, she was married to her husband, and her husband's dad, so her stepfather, decided it was time and necessary to get an estate plan in place for himself. He had been married several times and was getting married a third time, I think it was. And he went to an attorney and selected a trust-based plan for himself and his family, paid the lawyer $3,000 to put the trust together. This is several years ago. And felt pretty good about himself, thinking he had everything in order so that if he passed away, his main objective was he wanted all of his estate to go to his kids. If his things with his wife or wife-to-be didn't work out, he didn't want the wife to end up with everything or really anything at that point. I think she had her own estate that provided for her. So his main objective was to make sure everything went to the kids without any problems. While she was in law school, he actually did pass away, and because they knew he had a trust, they thought everything was taken care of. But to their surprise, after he passed, they found out that nothing had been funded into his trust, and everything passed through the probate court, and in fact ended up bringing the family into two courts, one in Florida where he lived and had a house, and one in Iowa, where he also owned real estate. He had to have probate cases in both of those states, and the estranged wife was now able to begin making some claims for some of that property. So she was able to get the family into yet a third lawsuit. The family was mortified. Number one, they're wanting to grieve the loss and not fight 3 lawsuits, yet here they were after he had tried to do the right thing and get a good, solid trust in place and funded. Allie, being the law student that she was, thought for sure that this would be considered malpractice, that an attorney that could take $3,000, put in a trust, and then the family end up in 3 courts had to be malpractice. And as she graduated law school and became an attorney and talked to a lot of different estate planning attorneys, and she herself became an estate planning attorney, what she found was that this was really common practice. It wasn't malpractice at all. Attorneys don't learn good service practices around getting estates in place. It's certainly easier for us just to give you a set of documents and a set of instructions and cover ourselves with paper and, document that we told you to do it. If you don't do it, then it's not on us. When in fact, that's really not giving you the most important thing that you're purchasing from us, and that is implementing the plan that we prepare for you. So I want to change the circumstances a little bit and tell you Allie's story just a little bit different if her father-in-law had gone to a documents plus comprehensive services attorney. He knew that, let's say he knew he was getting married and he was going to do a prenuptial agreement so that if it didn't work out, his third wife couldn't make claims to the inheritance that he wanted his kids to get. So he did a prenuptial agreement and he did a trust with a comprehensive or a curated estate plan attorney. And when he went into that attorney's office, the attorney just didn't sit there and tell him what he needed. The attorney sat for 2 hours and explored with him first what his life circumstances were. What are your dynamics? Do all your kids get along? Do you have a blended family? And so now you've got two bloodlines that you want to make sure share equally in the wealth. Or maybe you want to make sure only your bloodline shares and your spouse keeps their inheritance in their bloodline. What kind of assets do you own? Do you have real estate in other states? Do you have any of those edge assets that we talked about earlier that we really need to put a plan in place? Kind of look at what the tax laws are in place and the value of your assets to see if you've got any tax problems that now we need to plan around. It takes a good hour to 2 hours to really get into all of those important details so that as an attorney, I can know what plan will help you the most, and you will know enough about the law that you can tell me what plan you think would work best for your family. So together, I support you to make the choice, a will, a trust, or no plan at all, and I give you a flat fee, and I tell you what that plan and all those supporting or ancillary documents will cost, so there's never any surprises. You sign an engagement letter, and we right away go into drafting that trust plan in ways that are tailor-made to you. If you've got a special needs child, we've got a provision in there that plans for them. If you've got grandchildren that are 3, but you want to make sure if their mom or dad dies first, that their assets live inside your trust until they're 25 when they get half, and then 30 they get the other half. We really go into a lot of detail drafting the specifics. And we take all of the assets that you own and we list them on an asset inventory that during our time together becomes a checklist and a guide for you so that we know exactly what assets go into the trust, exactly what assets are going to go to specific people, and exactly what assets you want to keep in your name until you die and then transfer them into your trust at that time. And we make sure all your edge assets are listed on there. After you have your trust in place, we put that asset inventory in your portfolio, and you can see a sample of what that looks like on the table back there. And what that becomes is then a treasure map to your loved ones so that when they get your legal documents, they're also getting this map of where all your assets are, what you have, what they're worth, what the policy numbers are, and where they can find them. And that way they're not having to spend the first 3 months after your death watching your mail to see what statements come in the mail. They're not having to get your tax returns or tax transcripts for clues as to what you owned. I don't know about your family, but my family and a lot of families, we don't have a lot of conversations with our parents about what we own or with our children about what we own. And so it really is a mystery that has to be unfolded unless you have this asset inventory. So they've got that. The other thing that we like to do as a part of a comprehensive service is when you come in to pick up your estate planning documents after you've signed them, we invite you to sit for a video called a legacy interview. And it's a way to begin putting little short videos, maybe a little video library on a thumb drive, where you're telling a family story or explaining a value or a tradition that you think is important for your grandkids to hear, or maybe you're explaining why you made the estate planning decisions that you did on the video. Maybe you're fairly certain people aren't going to be too happy with your choices and you want to eliminate or reduce the fighting. So you've kind of put it on a video for your family to be surprised with when they take possession of your legal documents. So I think that's part of an important comprehensive estate plan. Then after your plan is in place, it's important, your life is going to continue to change unless you pass away the next day, and hopefully that doesn't happen to any of you. Your life is going to continue to change. The laws, the tax laws are going to change. You're going to buy and sell things. Your family, you're going to have new babies in the family. You're going to lose people. So really, at a minimum, every 3 years, you should be reviewing your estate plan to make sure that all those details that you wrote down in that moment that you did the planning are keeping up with the evolution of your life. And if they don't, you need to have access to your lawyer, a quick phone call or a quick email, just say, hey, this is where we're at. These were the choices that worked 3 years ago. Do I need to make any updates right now? I think that is extremely critical. The concept that you're reviewing your estate plan at least every 3 years, and you're updating your asset inventory every time you buy a significant asset or get rid of one. That way you know your plan is going to succeed when you need it to work for you, and you know your family is going to be well taken care of at that time. You also get the benefit of having an attorney or a law office that you know your family can turn to in their time of need. If something happens to you and they've got questions about how to administer the trust, we're just a phone call away. So I think there's a lot of benefits to the comprehensive estate plan approach, and that's certainly the one that we employ at our office.